Good afternoon and welcome. My name is Ken Gormley, and I have the privilege of serving as the 13th president of Duquesne University. And before my current job, as many of you know, I have the honor of serving as dean of the now Thomas R. Kline School of Law, and I've served on the law school faculty here for, it's hard to believe, 30 years now this semester. On behalf of the entire university community, we welcome Chief Justice Emeritus Tom Saylor, who in a moment will introduce this year's distinguished speaker. We're also honored to have with us Chief Justice Deborah Todd, Justice Christine Donahue, Justice David Wecht, all from the Pennsylvania Supreme Court. Could we have a round of applause for them? Also, former Pennsylvania Supreme Court Justice Cynthia Baldwin, Chief Judge Mark Hornak of the U.S. District Court, and other jurists. Can we have a round of applause for all of them? As you know, today is Constitution Day, commemorating the signing of the U.S. Constitution in Philadelphia on this date, September 17th in 1787. So it's really fitting that we gather here today for this special program, and we're proud that since its creation in 2017, the Thomas R. Kline Center for Judicial Education has truly become a model for the entire United States of a creative partnership between the law schools in a state and the state's judiciary to provide high-quality judicial education for our dedicated jurists. Since its founding, the Kline Center has collaborated with the administrative offices of the Pennsylvania courts to hold 22 judicial education programs in collaboration with AOPC and 6 independent programs on a wide range of important topics, and we work collaboratively with the state's other law schools to do that. Kline Center programs have featured preeminent legal scholars, including faculty from Pitt Law School, Penn's Carey School of Law, Harvard Law School, Stanford Law School, George Mason, as well as our own Duquesne Kline School of Law, and today from St. John's University School of Law. These programs are special because they routinely feature an interdisciplinary angle, tapping into the experience of the whole universities and other disciplines to help judges better understand the broader context that surrounds complex, thorny legal issues. First, a special thanks to the director of our Thomas R. Kline Center for Judicial Education, Professor Erin Karsman. Where is Erin hiding? There she is in the back. Let's have a big round of applause for Erin. She has poured enormous time and energy into organizing today's program, and also to our law school, Duquesne Kline Law School Dean, April Barton, who is here today, who has just done a fabulous job. And equally importantly, Chief Justice Emeritus Thomas Saylor, who has been instrumental in shaping the vision for the Kline Center and in building high-quality programs, including this one. Can we hear it for the Chief Justice Emeritus? I'm also thrilled, as a special celebration for Constitution Day, to make a special announcement about the Kline Center Fellows Program. It's now in its second year, and this is a really unique initiative that provides a select group of law students with opportunities that enrich and educate them about the work of judges and their law clerks, fostering a respect in both the judiciary and judicial education, which, as you know, is very important to us in this law school. We pride ourselves in public service as being a calling for our graduates. And so in the first 2 years, we've selected students from Duquesne Kline School of Law, and soon we plan to expand the fellowship program to include all law schools in Pennsylvania. So today, I'm honored to announce the 2024 Kline Center Fellows. The law students selected are Hannah Dean, Jury Barwa, and John Fazio, who are 3 L's, and Josh Kirkpatrick, who's a 4th-year evening student. Are you here? Can you stand up, you 4 students? Let's have a round of applause for them. Now for the main event. The Kline Center for Judicial Education is proud to welcome Professor John Q. Barrett, the Benjamin N. Cardozo Professor of Law at St. John's University School of Law, whom Chief Justice Emeritus Saylor will introduce momentarily. Professor Barrett and I have been friends and collaborators for many years. He's a leading constitutional scholar in the United States. He contributed a fabulous chapter on President Herbert Hoover to my book on Presidents and the Constitution, and he is the leading expert literally in the world on the work of the late U.S. Supreme Court Justice Robert H. Jackson, one of the most celebrated jurists in the history of the Supreme Court. Professor Barrett is here today to speak about Justice Jackson's involvement in one of the landmark cases of all time in American history, Brown v. Board of Education. Some of you know I devoted plenty of my own early research and writing on this topic. In fact, it was one of the great honors of my life. I was showing Professor Barrett before we came over picture, the chance to interview Justice Thurgood Marshall at his Supreme Court chambers before he died, who argued Brown in the Supreme Court. And we talked about, I produced then several major programs about his mentor, Charles Hamilton Houston, whom Justice Marshall credited with being the architect of the grand strategy to dismantle segregation in the public school system of the United States that culminated in Brown. He said the Brown case was really Charlie's victory. He had died a few years too early to see it. He said, I was just carrying the bags. But 50 years after the Brown decision, as a young faculty member in 2004, I organized a nationally broadcast program here at Duquesne on that historic case, and it included many of the then living participants in that landmark drama. 20 years later, it is still vital that we learn more about the figures who shaped that historic case, perhaps the most consequential decision in American legal history. And one such important figure is Justice Robert H. Jackson, whose contributions to the Brown decision were critical but are often overlooked. And there is nobody better qualified to remedy that than my friend, Professor John Barrett. So now to formally introduce our distinguished speaker and the subject of this program, it is my privilege to welcome Chief Justice Emeritus Thomas Saylor, who currently serves as the Judicial Scholar in Residence at the Kline Center for Judicial Education. A great friend of this law school, Justice Saylor served as Justice of the Supreme Court of Pennsylvania for 24 years, including more than 6 years as Chief Justice. Ladies and gentlemen, please welcome Pennsylvania's distinguished Chief Justice Emeritus, Thomas G. Saylor.
Thank you, President Gormley. I'm pleased to join in welcoming my longtime friend, Professor John Barrett of St. John's University, where, as President Gormley said, he serves as the Benjamin N. Cardozo Professor of Law. As President Gormley also pointed out, Professor Barrett is the nation's leading scholar of the life and career of United States Supreme Court Justice Robert H. Jackson, and we are indeed fortunate to have him with us today. Pennsylvania, of course, has a claim to Justice Jackson, as he was born in Spring Creek Township in Warren County on February 13th, 1892. Although as a young boy, age 6, his family thereafter moved across the New York state line to Frewsburg. In fact, his birthday is commemorated in an annual event held at the Warren County Courthouse in Warren, hosted by the Jackson Center, where Professor Barrett serves as a fellow. Educated in the public schools, Justice Jackson attended Albany Law School and, as was permitted in the early 1900s, read law in his uncle's firm. Admitted to the New York bar in 1913, he quickly rose to prominence in Western New York, eventually centering his practice in Jamestown, the county seat of Chautauqua County. As a young lawyer active in Democratic politics, he became acquainted with a young state senator from Hyde Park by the name of Frank Roosevelt, and the two men remained lifelong friends. Following Franklin Roosevelt's election as president, Justice Jackson agreed to join the Roosevelt administration in Washington, although intending to eventually return to his country squire life in Chautauqua County. From his first position as Assistant General Counsel of the U.S. Treasury Department's Bureau of Internal Revenue, his rise through the federal government of the New Deal was meteoric. He served as Assistant Attorney General, heading the Tax Division of the Department of Justice, and Assistant Attorney General in charge of the Antitrust Division. In 1938, he was named United States Solicitor General and was appointed Attorney General of the United States in January of 1940. In June of 1941, President Roosevelt nominated Robert Jackson as an Associate Justice of the United States Supreme Court, on which he served until his death in October of 1954 at the young age of 62. In 1945, following the death of President Roosevelt and the end of World War II in Europe, Justice Jackson took a leave of absence from the Supreme Court to serve by appointment of President Truman as the United States Chief Prosecutor of the International Military Tribunal convened in Nuremberg, pursuant to its implementing charter, which he was instrumental in drafting. This afternoon, however, Professor Barrett will focus his presentation on Justice Jackson's deliberations in the landmark case of Brown versus Board of Education, decided 70 years ago this past May, in which the 9-member court unanimously decided that public school racial segregation is unconstitutional. Although Chief Justice Warren authored the Brown decision for the court, Justice Jackson played central and still not well understood roles in Brown's deciding, and Professor Barrett will share with us for the first time that significant story. Professor?
Happy Constitution Day, and thank you so much, President Gormley, Chief Justice Emeritus Saylor, Dean Barton, Thomas Kline, the Thomas Kline Center for Judicial Education, especially Aaron, everyone at Duquesne Kline School of Law, justices and judges. We are gathered here today because of the anniversary of what occurred here on September 17, 1787. That is the Pennsylvania State House, which was taken over by delegates from the Confederation Congress from May through September of that hot summer of 1787. Their project to tinker with the Articles of Confederation, of course, became a runaway constitutional convention. They threw out our first Constitution, they started over, and on September 17, this date, they unveiled to the states, to the audience, to the newspapers, to the public, the proposed document that would become the U.S. Constitution. These are the Founding Fathers, 50-plus men, all Caucasian, all propertied, some slave owners, who did this work. I would like to add to this Constitution Day additional framers, because in addition to these architects who created the articles, the top of the Constitution, the structural provisions, if you will, there are amendments that are part of the Constitution that we celebrate. And this is a depiction of the vote that sends the draft 14th Amendment to the states, which becomes a part of our Constitution in 1868. So these are the 19th century framers. This perhaps is a third Constitution to think about. It's our modern equality Constitution. And of course, this one is central to Brown versus Board of Education, which I will be discussing. This Constitution Day involves the Supreme Court, and a justice will be my particular focus, as Chief Justice Saylor said, Robert H. Jackson. This court, headed by Chief Justice Earl Warren, is the 1953-54 court that decided Brown. And across the front row, that is Justice Felix Frankfurter. On the left, Hugo Black, Chief Justice Warren, Justice Stanley Reed, and Justice William O. Douglas. And the back row from the left is Justice Tom Clark, Justice Robert Jackson, Justice Harold Burton, and Justice Sherman Minton. This is the Brown Court. And this is the particular focus, Robert Jackson. If you go back to this previous photo, which is a highly stylized pattern of location, you notice that Jackson is not very senior. The front row is the senior, and the far right back row is the junior, and then 9, 8, 7, 6 is Jackson. So he is still in the youth half, the younger half of the court, and never rose to be part of seniority, the top half of the court. Nonetheless, we remember him, we study him, we revere him, because he left an incredible mark in our constitutional law, our legal history, our government, and our American model in just 13 years of Supreme Court service, one of which he missed because he was AWOL, serving as the chief prosecutor of the Nazi war criminals at Nuremberg. So my topic is Jackson and Brown versus Board of Education. Why Brown? Well, Brown is, in a sense, a Constitution Day. May 17, 1954, a move to realize the 19th century constitutional text, the promise of equality, the majestic enactments following the Civil War that, of course, had not been delivered on for the many decades between then and 1954, and perhaps is still a Constitution Day challenge for us this year and tomorrow and next year and so forth. Why Jackson? Well, Jackson is a lawyer and judge. He is a constitutional judge, including in Brown. He is a life in his time, which meant working on its challenges, and they turn out to be big, permanent, enduring ones. Some time periods from the past and some endeavors are period pieces, are history, are interesting as past events. What Jackson happened to live and participate in is still our stuff, and so he matters at that level. He's also very accessibly human, and thus you can sort of feel, although he's been gone since 1954, the man in the room, the guy in the fishing boat, the friend on the adjacent horse, because a lot of that is in the work he left on the paper, both the opinions and all the drafting and work that he did leading up to that process. And he was distinctively honest. He thought through his pen and often tried to work things out on paper. And we have the ability in the Brown story to sort of walk that path with him in a way that we don't have with some of the others. Finally, he's just powerful in his words and example. As Chief Justice Saylor referenced, he is revered, he is much quoted, he is identified and sort of opportunistically sometimes claimed by lots of today's jurists because wrapping yourself in some Jackson elevates you. So I will approach this lecture in 4 parts. First, I'll talk a bit about him. Second, I will walk through the timeline of Brown, the decision and the cases, which is really a 3-year story. Third, I will talk about Jackson in the Brown timeline. And fourth, I will talk about understanding, how we should think about Jackson, what he did in that timeline, in the Brown timeline. So part 1, William Penn, founding father of this Commonwealth, a Robert Jackson ancestor, allegedly, murkily, there's a name, there's a genealogy, I can't quite prove it, there's no DNA testing, but it's a claim. So how's that for a Pennsylvania claim? In addition, He was born in the Commonwealth of Pennsylvania. As Chief Judge Justice Saylor said, he was born in this little house on the banks of the Broken Straw Creek in 1892 in Spring Creek Township in Warren County in northwestern Pennsylvania. He, of course, moved to bigger stages, but a lot of the Pennsylvania, the wisdom, the individuality, the autonomy, the rural American independence never left him. And that's part of the thread that we will trace through the Brown case when we get up to these bigger stages. He also was a Pittsburgh man. This is a glimpse of Jackson in that first presidential appointment as general counsel of the Bureau of Internal Revenue, cross-examining Andrew W. Mellon at the federal courthouse down the hill in 1935, when the Treasury Department had filed a deficiency notice against Mellon for being, if I may, a big tax cheat. And Mr. Mellon had counterclaimed, alleging that he was a big tax overpayer, give me my refund. This was not a criminal case. There was an effort to indict him, and the grand jury in Pittsburgh, probably a prosecutorial error, returned a no true bill. But then a civil case before the Board of Tax Appeal commenced. And it literally was Jackson cross-examining Mellon. Every year has a trial of the century. But in 1935, this event, and I don't have to tell a Pittsburgh audience, this high publicity prosecution of Andrew W. Mellon regarding his wealth was a headline event, not just in Pittsburgh, across the country. And Robert Jackson is rising to prominence as the point man for the government in this action, which in the end is resolved with a decision after Mr. Mellon has passed away against Mr. Mellon's claims. $400,000, real money in those days, was paid by the Mellon estate to the United States. And coincidentally, entirely unrelated, I assure you, Mr. Mellon, before his death, had spontaneously decided to donate his art and the money to build the National Gallery of Art, which Franklin Roosevelt privately referred to as Bob Jackson's Museum. In addition to being a Pittsburgher, if I may, and there is still the Pittsburgher building, I noticed, downtown, which is where Jackson lived in 1935 during his litigation time here. Jackson was honored as Pennsylvania Chamber of Commerce Pennsylvanian of the Year in 1950. So this is the telegram delivering the news, and this is the presiding official from the chamber presenting the plaque at the dinner at which Jackson was honored. It's not quite the Rooney Award, President Gormley, but it's, in its moment, something big in Pennsylvania. In other words, Mellon and all of that stuff 15 years ago was kind of bygones, at least to the chamber, at least at this level of statewide recognition. And Jackson came home to receive this award. Jackson rises the path that Chief Justice Saylor chronicled. He's nominated 6 different times by President Franklin Roosevelt to executive branch offices and confirmed by the Senate. It's really 5 offices because the first one they had to do twice for procedural irregularities. But General Counsel of the Bureau of Internal Revenue, Assistant Attorney General in the U.S. Department of Justice, Solicitor General in the U.S. Department of Justice, Attorney General in the U.S. Department of Justice, and then Associate Justice of the Supreme Court. And all of that within 7 years, and all of that concluded in 1941 when he was 49 years old. It's a little dizzying. Plus, along the way, he was briefly detailed to the SEC to litigate a high-profile matter in the Supreme Court in 1936 and did other special projects. So Mellon, that trajectory, et cetera, you can sort of understand why this is a man for big responsibility and big challenges. This is Jackson thinking, maybe posing, but thinking at his Attorney General desk in DOJ. This is Jackson posing awkwardly, and the bright flash almost makes it look like a mug shot when he's appointed to the Supreme Court in the summer of 1941. This is Jackson at civilization's podium in courtroom 600 in the Palace of Justice in Nuremberg, Germany, in the fall of 1945. By appointment of President Harry Truman, and this one didn't require the Senate, this was just an executive hire, if you will, a phone call from the White House to the Supreme Court, which would not happen today, transgresses our notion of separation of powers, but in their day was a more common thing for Supreme Court justices to do extrajudicial service. And it was Harry Truman, a new president, with a heck of a commitment that he needed to staff with what he regarded as the country's finest lawyer. At the time Truman makes the call and makes the job offer, he's really asking Jackson during the summer recess of 1945 to prosecute Adolf Hitler, which is a pretty good job offer. And if you're not entirely contented on the Supreme Court and you have a recess coming up and you're told that it's all ready to go and it's just a stature matter and the evidence is there and the Allies' international plan is there and so forth, and as a patriot, you say yes. And all of that turned to ash, no Hitler, no inner circle with the exception of Hermann Goering, no international agreement, no gathered evidence, no location. Jackson has to sort of create the world's first international criminal court, and with allies write the indictment, and with a staff gather the evidence, and in November of 45 begin the case, and in public try this case over the next 9 months, concluding in October 1, 1946 with the return of the verdict, and thus skips out on a year of Supreme Court service. For the jurists, think of your beloved colleagues, and then think of one of them taking a little bit of a busman's holiday and leaving you with their share of the work for a year. Jackson did it. Truman asked him to do it. It turned out to be a big job, and he stuck with it. And he said for the rest of his life, no justice ever should do this again. He did try to resign from the Supreme Court, and Harry Truman said, oh, no, those 8 can do the work of 9. Let me turn to part 2, the timeline of Brown versus Board of Education. This is a photograph of the Topeka parents in the back row and some of the children that were the Topeka class challenging de jure racial segregation in the Topeka, Kansas schools. In other words, by race, assignment to a black school, and however proximate it was to your house, by law, a prohibition on attending a so-called white school. The third from the left is Linda Brown. She's in front of her father, plaintiff Oliver Brown. Other plaintiffs in this group, a little tidbit from Brown versus Board of Education, had surnames that began with an A, but Mr. Brown was the first man alphabetically. And so the case got named Brown versus Board of Education rather than Mrs. Apple. I draw here, and I recommend, the work of many major historians. 4 that I flag in particular for your further study, appreciation, real immersion, because I think this is our Constitution Day forevermore, is Richard Kluger's majestic book, Simple Justice, Professor Mark Tushnet's 2 volumes of biography of Thurgood Marshall, Making Civil Rights Law and Making Constitutional Law, Professor Michael Klarman's majestic book, From Jim Crow to Civil Rights, and Professor Brad Snyder's recent biography of Justice Felix Frankfurter, Democratic Justice. Each of them, and with some debates along the way, builds our understanding of Brown of 1950s through 1955, and we still don't have it all yet. It's worthy of more work, and in a small way, I hope to contribute to that. Brown proceeds, of course, against a backdrop. I want to just put this out, tick it off, you know it, but we should say it explicitly. 1787, our founding, and the compromise that the document makes by avoiding the topic of slavery. The institution of slavery, continuing as a federal legal matter to 1809, no ban on international importation until then, and in southern states as a legal property arrangement up until the Civil War. The Civil War itself, a constitutional convention of a different type. Grant v. Lee, I guess is what some jokingly call that case, but a different type that produced a different constitution. The new constitution that emerges, 1865, 69, 68, 69, which is the Equality Constitution I mentioned, the 13th Amendment, the 14th Amendment, the 15th Amendment, and the Reconstruction process that makes possible. And then beginning in 1876, the era of returning white supremacy that brings Reconstruction to an end. And that is Jim Crow, and that is segregation. And that is the Supreme Court approving de jure segregation in a transportation setting, railroads, in Plessy versus Ferguson in 1896. After the Great War, the First World War as it later got renamed, the 20th century begins fitfully to deal with racial segregation. The NAACP is founded. Northern disapproval of Southern segregation becomes a more defining regional politics. In the 1930s Supreme Court, under Chief Justice Charles Evans Hughes, there are rare but important decisions in racial injustice cases that bring the Constitution to bear on this practice. Powell versus Alabama, involving the Scottsboro defendants, nicknamed, of course, in a diminutive, patronizing, racist way, the Scottsboro Boys. The Sippuel case, the Gaines case. Gaines is a law school admissions case. Those are decided in the 1930s, but they are spots. After World War II, the Supreme Court begins more actively to get into the business of delivering on the 14th Amendment, and particularly the Equal Protection Clause. This is the Vinson Court. That is Chief Justice Fred Vinson in the center, next to President Eisenhower. This is a White House visit in the early 1950s, 1953 actually, Vinson's last year. And you see arrayed around the president, the court that is the Vinson Court. Front row, Justice Douglas, Justice Reed, then Vinson and Eisenhower, Justice Black, and Justice Frankfurter. In the back row, the Attorney General, Herbert Brownell, and then Justices Minton, Clark, Jackson, and Burton. This court, 1946 through 1953, begins to do real work interpreting and applying the Constitution in the realm of racial discrimination. For example, in 1948, in Shelley versus Kramer, this court, 6-0, with 3 justices recusing, strikes down racially restrictive covenants on property that create a cause of action in court that allow neighbors who object to an interracial sale to try and enforce a contract term. The Supreme Court says that's state action using race prohibited by the 14th Amendment. In 1950, and we will come back and spend some time on this, the court in 2 very significant cases holds de jure racial segregation in higher education to be unconstitutional. Separate here, higher education, graduate school, cannot be equal, holds the court. 9-0. This is the case of Sweat versus Painter, involving the law school at the University of Texas, which was all white, and then in an effort to defend in court the creation of an all-black segregation law school, the University of Texas Law School for Negroes, which was demonstrably a pale shadow of the University of Texas Law School, invalidated in Sweat. And in McLaurin versus Oklahoma Board of Regents, involving the Graduate School of Education, physical segregation within one class of an African-American student. You must sit in the alcove. You must sit at your own table. You may not sit with the white students. 5 feet away is okay. Hearing the same professor is okay, but we don't want this adjacency, is invalidated by the Supreme Court. 9-0. These decisions in June of 1950, of course, tee up the next horizon in the Charles Hamilton Houston campaign, which is the Thurgood Marshall campaign. He's not just carrying the bags. He's doing the work and running the teams and planning the cases and risking his life by litigating in lots of southern states, to look at elementary and secondary school segregation, to challenge de jure racial segregation, not at the graduate school level, the university level, but down at the high school level and indeed at the elementary school level. The Supreme Court stalled these cases at first. They come to the court in 1951 and the court slow rolls them, sends one back for consideration, puts some on hold, doesn't conference, and so forth. So nothing is happening until 1952, which coincidentally puts these cases on the calendar to be argued after the next presidential election. So by slow rolling in 51, no arguments in spring of 52, the first arguments happen in December of 1952, by which point Eisenhower has defeated Stevenson and politics is out of the way, it's at peace. We'll see in December, of course, this year, how we'll have an election, it'll be smooth, somebody will win, and then politics will be out of the way, and we will be at peace in December. I pray. These are 4 cases from states: the Brown case from Kansas, the Gephardt case from Delaware, the Davis case from Virginia, and the Briggs case from South Carolina. That is, respectively, a Midwestern border state, an East Coast border state, a northern state of the Confederacy, Virginia, and a Deep South case from South Carolina. Plus, there's a federal case involving racial de jure segregation in the public schools of the District of Columbia, which is the U.S. government's District of Columbia. And that case, Bowling versus Sharp, is the fifth case within this constellation. They are argued to the court over multiple days in December of 1952. This includes Thurgood Marshall against John W. Davis. This includes Robert Carter, later a federal judge. This includes James Nabrett. This includes Spotswood Robinson. It is a pantheon of NAACP litigating heroes who are on that side of the case. And it is state government officials defending their way of life, their constitutional prerogative. They're following the long-approved path of Plessy versus Ferguson, which says equal just requires comparable, not together. And so separate but equal is consistent with the 14th Amendment. In the conference following these oral arguments in December of 1952, the justices decide to take no vote. They have extensive discussion, and thanks to the conference notes that many of them kept and that history preserved, we're able to do a fair amount of recreating the conversation. And what is going on in that room is divided views. A court that's not of one mind or even close to one mind. And so shortly thereafter, beginning in early 1953, the arguments within the justices, led by Justice Felix Frankfurter, are delay, delay, delay. Instead of deciding this in a fractured way and maybe in a regrettable way, let's keep percolating. Let's keep discussing. Let's keep thinking. And eventually, Frankfurter sort of ups the argument and says, let's call for re-argument. And he drafts 5 questions, which his colleagues approve, which in spring of 1953, the court hands down, saying these cases will be restored to the calendar, and we want additional briefing and oral argument on these questions. The first 3 concern what we would call the original intent and the original meaning of the framers of the 14th Amendment in 1868. What did they, writing equal protection, think it meant about school segregation? And since that question might point in the direction of good news for the states, the 4th and 5th questions pointed in the other direction, good news for the NAACP. In the event that segregation is unconstitutional, what remedial path should the court take? Is forthwith integration the constitutional command? Should it be unconstitutional? And other related questions. And the justices are very carefully both acting and not acting and signaling but cross-signaling to buy more time. And then Chief Justice Vinson drops dead. In September of 1953, shortly before that new term was to start, shortly before those re-arguments were to occur, on a Monday night, after staying up late and watching football, not Monday Night Football, it wasn't called that yet, and not the Steelers, I checked, but watching a game, the chief, who was a big smoker and not a vigorous exerciser, and etc., doesn't make it to the morning. And so that is the end of the Vinson Court. Then comes the Warren Court, the court that produces in 1954 this celebratory moment on the steps of the Supreme Court in May 1954. The second year of Brown, if you will, is the path that I now want to walk. This is the court with the new chief. Earl Warren had been the governor of California, before that the Attorney General of California, re-elected really by acclamation the last time. He was the nominee of both the Republican and Democratic parties when he was re-elected in 1946. And thus he was picked by Thomas Dewey to be his vice presidential running mate in 1948. And of course we know that Dewey beats Truman and Earl Warren became vice president of the United States. Or not, because history sometimes takes surprising turns. But that could have been Earl Warren. Instead, Earl Warren's been governor for a long time, and he's supported Eisenhower at the Republican convention in '52. It wasn't automatic. Robert Taft was running against him, and that support from California sort of put Ike over the top. And Earl Warren said, basically what I want to do is serve on the US Supreme Court. And Eisenhower said, yes. And so Earl Warren, in the summer of '53, is resigning from the governorship and preparing to be appointed to be Solicitor General of the United States so he can have his first Supreme Court argument and spend some time in Washington and the work of the Supreme Court from the advocate side before, in due course, Eisenhower appoints him when he gets the Supreme Court vacancy. And then Vinson dies, and Warren says, when should I show up? And Brownell, the Attorney General, and Eisenhower, the President, sort of hem and haw briefly, like we weren't thinking about Chief Justice, we meant Associate Justice, first vacancy didn't mean first vacancy, and Warren basically says, do I need to call a press conference? And it is September, and the Supreme Court is about to begin its term on the first Monday of October, and so Earl Warren becomes Chief Justice of the United States. Not by senatorial confirmation. At this time, the Senate is not in session. The Senate didn't meet until December of the odd-numbered year in those days. So it is a recess appointment. But it puts him on the bench the first Monday of October, and it puts him on the bench for the cases that are being re-argued, the Brown cases. They are re-argued in December of 1953. Same 5 cases, the additional briefing, a few new participants, but the historical debate and a rehash of the previous year's debate, multiple days of argument. In conference, the justices, again, as the previous year, Warren, following the Vinson decision, take no vote. We're just going to talk. But unlike the previous year, in that conference, clearly in the notes, there is an 8-to-1 majority to interpret the Constitution, the Equal Protection Clause in the 4 state cases, the Fifth Amendment Due Process Clause in the federal case, as prohibiting de jure racial segregation in secondary and elementary schools. And Justice Stanley Reed of Kentucky is really the lone voice to reaffirm Plessy and to reaffirm segregation. But Warren is a recess appointee. And they're talking and they're expressing views, but they're not taking a vote. It's not until March of 1954 that Warren is confirmed, and then thereafter, finally, the court votes. Interestingly, since this is a very close hold confidential matter, there's not a document. The date is one of 4 possible dates. The vote might have been 9-0 or might have been 8-1. Nobody wrote it down because the chief said, don't talk about this with your law clerks and don't write it down. Now, some of them were taking conference notes, but nobody was writing down a vote tally sheet. And then Warren goes to work. He goes to work personally, lots of office meetings, lots of conversations in the hallways, lots of walks around the Supreme Court building, and particularly with Stanley Reed. At some point, Stanley Reed, who had drafted a dissent, which also went into a burn bag or a fireplace and doesn't survive, comes aboard. And Brown will be unanimous. And then Warren starts writing. He drafts. The drafts are circulated. The joint votes are gathered. It becomes official in early May of 1954 that this is a 9-0 court. And on May 17, 1954, the court hands down the decision. The Brown decision does a number of interesting things. It rejects originalism. It says the history is inconclusive. This doesn't help us here. It proceeds prospectively. It does not, despite regular erroneous statements to the contrary by the U.S. Supreme Court, and I am talking to you, Justice Brett Kavanaugh, among others, it does not overrule Plessy versus Ferguson. It simply says, henceforth, the rule will be. Because this court is not going to blame prior courts, just like this court is not blaming the South. It's saying, henceforth, separate cannot be equal in the realm of education. And it explains what has changed since 1868 or 1869 by focusing on 2 particular things. The place of public education today is state required, is universal, is important in advancing the country to the success economically, militarily, diplomatically, globally that the United States needs. That's why we have schools. In the 19th century, schooling was rare, it wasn't state compelled, etc. Education is different. And this is a kind of benighted and patronizing thing in the Brown opinion, African Americans are different now too. In 1868, these were people who recently had been liberated from chattel slavery, where they had been prohibited to marry, to live with their families, to go to school, to read, to own property, et cetera, et cetera, et cetera. Not surprisingly, for the mass of African Americans, the condition at the time of the 14th Amendment is deeply disadvantaged. Whereas today, 1954, says the Warren Court, the place of black people in the United States, their attainments, their accomplishments, their potential, is an entirely different thing. Henceforth, and thus the decree. A year later, at the end of that decision, the court again sort of remands it for additional briefing and says, we're going to have arguments the next year on remedy. So even by deciding Brown in year 2, they're not done with it. They're slow rolling towards the remedy question. And in 1955, that becomes the briefing and the oral arguments and the decision that we call Brown 2, which is the court holding that the remedy should be worked out at the trial court levels, in the communities, with all deliberate speed. And of course, that ambiguous phrase, that is a brake-ish accelerator, or an accelerator-ish brake, all deliberate speed, is a rhetorical handhold for racists and massive resistance, and a lot of what transpires with great difficulty, and then it takes the civil rights movement to begin to deliver on Brown for the rest of the 1950s, Montgomery bus boycott, Martin Luther King, SCLC, 1960s, Civil Rights Act, Voting Rights Act, etc. This is a 1963 painting by Ben Shahn, a great American kind of radical artist, I think is how you would categorize him. It's called Supreme Court Integration. And I'm not an art critic, but a few things strike me about this picture. One, the whiteness of the men. Two, the smallness of the men compared to the pillars and the height of the room, which in a sense is the airspace, the challenge, what looms over them. Three, the face of Robert H. Jackson, second from the left. This is the seating equivalent of the group photo that I talked about earlier. And so now I'd like to turn to my third part, which is the story of Jackson in Brown, the timeline of him dealing with this issue of racial segregation. His upbringing, as Chief Justice Saylor previewed, was rural life. He descended from self-sufficient farmers. They were Democrats in the Jeffersonian, Andrew Jackson, 19th century sense. They were isolated in Warren County, Pennsylvania, and in Frewsburg, New York. There were black people, but only a few. And they were there, and we were here, and my family raised our crops, and yours did whatever they did. And that was this kind of integration, such as you will, of Jackson's life at the start. He had limited education. He never went to college for a day. He went to law school for 1 year and read law on the 2 adjacent years, becoming a lawyer at age 21. So high school, apprenticing, a year of law school, which was kind of memorizing cases in those days, makes him a lawyer. That's not a lot of deep study of American history and the topics that are involved here. He inherits the lost cause view of Reconstruction, that the war itself, the Civil War, was kind of hotheads on both sides. It could have been avoided. And that Reconstruction was some great oppressive incursion by northern white Republicans trying to capture economic opportunities and control the southern states. And thank God that came to an end. That was the standard American history, the lost cause view. And that's why Civil War memorials and statues of Robert E. Lee blight our landscape. And Robert Jackson and this court grow up in and largely believe all of this. Jackson's law career in Western New York, both Buffalo and then Jamestown, is in a very white area. He's successful. He's prosperous. He's what we would call racially privileged. That includes limited contact with black people. A few were his clients, a couple of quite significant cases. He was a pro bono lawyer for people who couldn't pay and was willing to sort of, even as a big shot, represent the desperate person who needed a lawyer, and sometimes that was a black person. They were also his servants. He had household employees in his prosperity in Jamestown. He had a horse farm that had a caretaker who was a black man. And the words that circulated around him included disparaging things. One, which I'll actually say, is darkies, because in letters, his sister uses that word to refer to the horseman who works for Jackson at the horse farm. Another that I won't say, but the N word, is something that Jackson used in a letter quoting a joke in the mid-1930s. Not referring to a person, but talking about an N-word type of worthless document, which is a throwaway line, but is a racist line. That's his climate. He meets segregation in 1934 when he moves to Washington, D.C., that first appointment to the revenue job. He's living in and seeing de jure segregation in the Capitol. And he travels to the Deep South as a government official and sees Alabama and Mississippi. His government lawyering is a white core of lawyers. On the one occasion where he had to personally deal with a racial exclusion issue, he did what we would commendably regard as the right thing. He as the Attorney General, controlled the D.C. Courthouse Law Library. I don't quite know why, but that was something that the Attorney General controlled, which was a whites-only law library. And the Black Bar Association of D.C. said, hey, we can't use this law library. And Jackson orders that there be access for the black lawyers. In other words, kind of separate but equal, but at least access. His core work in Washington is being part of broader political and legal fights, including litigation, against judicial supremacy, against court imposition of values and control on the political process. This is the New Deal fighting the anti-New Deal Supreme Court. Jackson's part of it. This is the court packing proposal of 1937, which Jackson is a testifying champion of. A proposal that really becomes unnecessary because departures turn the Supreme Court and it becomes a friendly court. And then Jackson is arguing to the court. Assistant Attorney General, Solicitor General, Attorney General. He argues over 40 cases. And he's generally arguing the Constitution doesn't stop states from doing progressive things. The Constitution doesn't disable the Congress from legislating progressive things. The politics is the core power of this country. Interpret the Constitution small and get out of the way of the political process and the people. And he wins those cases. And of course, that's a formative mindset which he takes to the Supreme Court. In 1941, he becomes a justice. This is a new role, and Jackson is very conscious of it. Judging is not politics. Putting on the robe covers what was there before. And he is beginning to decide race cases as a justice. He's not a justice crusader. There are examples in his work files of him struggling with equality arguments and justice outcomes. But he mostly casts what we would call good racial justice votes, or at least he casts no awful votes in these race cases. And he starts to notice and understand more the human and legal consequence that becomes, later, the Brown litigation. For example, in November of 1943, William Henry Hastie, an African-American lawyer, later the first black federal judge, a judge of the Third Circuit, argues in Smith versus Allwright against the white primary. And Jackson is exuberant, recounting later to family members this incredible Negro lawyer and his stunning performance. And the court decides in Hastie's favor in Smith versus Allwright. In 1944, Jackson pens his dissent in Korematsu versus United States, which is about the exclusion of Japanese Americans from the West Coast. And it's a complicated opinion, but its punchline is about race. Jackson says if the court's going to get into wartime issues, it can't approve racialized criminal procedure because our Constitution prohibits drawing lines based on race. And then he goes to Nuremberg, which is so many things, but it's an immersion in totalitarian racism among them. The Jewish race was Nazi nomenclature and general world nomenclature at the time. what we come to understand as the Holocaust is a racial, to the Nazis, exterminationist campaign. And what Jackson is doing at Nuremberg is, in a sense, discovering it, comprehending it, prosecuting it, and then, of course, bringing home all of that. In 1948, when the court decides Shelley versus Kramer, the 6-0 Shelley versus Kramer, Jackson is recused. Because what he's done is pulled out his property deeds, and he's found racially restrictive covenants on his former house in Jamestown. And he, with 2 others, says that's an appearance issue and we're better off not participating in this case. I think also because the die was cast and it was clear there was a court without them. In 1950, and here we will dig in a bit, Jackson does important work thinking through Sweatt versus Painter and McLaurin versus Board of Regents, the higher education cases. He is legally unsure about the meaning of the 14th Amendment Equal Protection Clause with regard to segregation, racial segregation in higher education. He has recently been part of the court delving into the original meaning of the 14th Amendment in a case called Adamson versus California with regard to whether the 14th Amendment incorporates the Bill of Rights as limiting the states. Did the framers of the 14th Amendment mean to do that? And important to the majority in Adamson, which concludes not total incorporation, but selective incorporation, is work by a historian who's both a political scientist and a law professor, in addition to a historian, at Stanford University named Charles Fairman. This is Sweatt. This is McLaurin in his alcove. And this is Charles Fairman. Jackson, having high regard for Fairman's 14th Amendment scholarship and dealing with these cases as they're coming on, reaches out to Fairman and says, in confidence, will you help me with your knowledge and thinking through what the 14th Amendment means with regard to racial segregation in higher education? Now, what is the Supreme Court justice doing, writing to some random professor in Stanford, asking for him to sort of be his brain trust? Well, he's doing 2 things. One is, he's going to someone he knows and trusts long before the Adamson case. Charles Fairman had been at Nuremberg. Charles Fairman, as a professor, had, after Pearl Harbor, enlisted, was in the JAG Corps, did legal work, and then post-war is doing government occupation reconstruction work, and from Berlin is working with Jackson in Nuremberg on this project, which is Hitler in the heart of Nuremberg, which is Hermann Goering, the lead defendant, in front of him, which is what the Nazis were and did. So Jackson knows Fairman, and he knows Fairman from this. And he also quips, it's not considered improper for a Supreme Court justice to hire a boy just out of law school and rely on his advice for thinking through and deciding cases. Sorry about the sexism, but male law clerks. If that's fine, it seems fine for me to reach out to you in confidence and have this relationship. And so Fairman and Jackson, by letter, go to work cross-country in 1950. And these are wonderful documents. I'll read a few paragraphs from Jackson's letter of March 13, a month before oral argument in Sweatt and McLaurin. My dear Fairman, I'm glad you're willing to let me draw on your researches and informed judgment as to constitutional questions. I was brought up in a community where no serious racial problems or tension existed. My real concern, insofar as I can read my own feelings, is to see this thing decided wisely rather than to see either side win. But if it chances to be wisely done, the wisdom seems to be a byproduct. Everybody's so het up about this. Everybody's sure it is a no-brainer in their direction. Perhaps because of so much irrationality and the scarcity of materials, I can't figure out whether the 14th Amendment means this or that. You and I, and I'm jumping around, you and I have seen the terrible consequences of racial hatred in Germany. We can have no sympathy with racial conceits which underlie segregation policies. Neither can we overlook that widely held beliefs and attitudes, even if mistaken, are real factors in law and statecraft, and a state of mind may be a real hazard as a mountain range or a river boundary. In other words, I'm trying to come to this with an open mind and figure this out. And so Jackson goes forward. I propound 8 questions. The parties later in Brown only get 5 questions to rebrief from Felix Frankfurter. Charles Fairman gets 8 questions from Robert Jackson. Each is a full paragraph. And they are comprehensive, they are interesting. What's the function of the court? If we do have a role, what's the historical evidence? If the historical evidence says the 14th Amendment disapproves segregation, how come everybody thereafter did segregation and the Supreme Court upheld it? Is there a basis for distinguishing graduate schools from elementary and secondary schools? If segregation is forbidden generally in education, what are the special circumstances of remedying it immediately or some phased thing? If it's unconstitutional in the states, what about the District of Columbia? What about the attitude of the states and resistance? What about the probability of backlashes either from white or from black, depending on how these are decided, et cetera, et cetera? That's an assignment. And I assume Professor Fairman was teaching his full load and doing his ordinary work. He does seem to drop everything and work really hard to give his best advice to Jackson. If I can summarize it, and I'm summarizing some very long letters, Fairman says that the answer on the segregation question is not to be found in history. I poured through the 14th Amendment, and it's not there. It's not clear in either way. What we would call originalism or original public meaning isn't accessible. So don't hope that history will deliver the path to you. Instead, the court should move forward with the US people, with the history of this country. That's our story, fitfully, partially, slowly, imperfectly. But the Supreme Court does best when it's not holding its hand up against the tide, when it's instead engaged with the movement of its time. And Fairman concludes a long, personally typed letter filled with typos, and then he handwrites a PS because of the confidentiality of this. I did this at home. Nobody at Stanford helped me type this letter. Nobody knows about these correspondence. He writes, all of this may suggest that I am like one of the old-fashioned elders who, if invited to offer prayer, couldn't stop until he had given the Lord detailed instructions on how to run the universe. And I beg leave to pray again if on further thought I think of something better to pray for. Robert Jackson sends this telegram back to Charles Fairman 2 days before the oral arguments in Sweatt and McLaurin. Letter received. Keep praying. In other words, we're trying together, and this court is trying, and I'm trying to figure this out. Ultimately, the court 9-0 in Sweatt and McLaurin holds that separate cannot be equal in the realm of higher education, because no second University of Texas created law school will be UT. And no being near the heart of the classroom is being in the classroom. There's one thing here, which is the thing that equality demands equal admission to. And Jackson doesn't write, but he votes in that case. Now Brown. In December 1952, when the court is first hearing oral argument, Jackson thinks this is a different question because elementary and secondary schools aren't unique. UT is UT, and the alternative black law school is never going to be UT with the alumni and the power and so forth. Duquesne, Kline School of Law is and only is this place. But PS this and PS that, middle school this, middle school that, high school this and high school that, these are interchangeable things. So we're looking at a different question. And we are looking at something on which I, Robert Jackson, have political conviction. I think it's wrong, I think it's ugly, I think it's indefensible to keep kids out based on race. But what's the honest legal argument that the Constitution compels that they be admitted? That's what Jackson is looking for. And he is the one who says in the conference in December of 1952 to Chief Justice Vinson, let's not vote. Let's talk. Let's thrash. Let's hear each other. Let's keep conferencing. Because I don't think I'm here and I don't think we're here in understanding this. And he's with Frankfurter, Jackson is, in delight about the delay. It's put over for re-argument. And by the way, in May of 1953, as that process is occurring, Robert Jackson, age 61, thinks he's dying. He has a large tumor on his thyroid, which the doctors tell him looks very bad. And he knows people who've died of thyroid cancer. He puts his affairs in order, his will, his property, writes letters to his dearest lifelong friends that are sort of goodbye letters. and then has the operation, and it's not cancerous. This moment, and I think this personal experience is a bit liberating for Robert Jackson to live his future and perhaps to be more humane, however near or long that future will be. And so he is on the court in the fall of 1954 when the deciding of this case occurs. This is Black on the left, Jackson in the middle, and Frankfurter on the right in September of 1953 at Vincent's funeral. Jackson, in this moment, almost becomes Chief Justice. That's Eisenhower's initial inclination, a bipartisan move, elevate a Roosevelt guy to the center chair. It, of course, doesn't happen, in part because of Earl Warren saying, we've got a deal. But Jackson is continuing to think and continuing to work. In December of 1953, the court hears its re-arguments, and in conference we know many of the same concerns are there. But Jackson is particularly, demonstrably dazzled by the NAACP oral arguments in December of 1953. He asks a question to Thurgood Marshall about what the 14th Amendment means about Indian reservations, the federal government's treatment of Native Americans, which is a tough question. And Thurgood Marshall, a Mason, as Robert Jackson was a Mason, does a secret Masonic distress symbol, which is to wiggle the knot of your tie, and kind of smiles at Jackson. And Jackson immediately picks up on it and wiggles back and moves the questioning to another topic. This is covered in NAACP memoirs, including Jack Greenberg's. When the arguments are over, Jackson bounds down the hallway into Frankfurter's chambers. They were extremely close, and there was a lot of this running in both directions. And without noticing that Frankfurter had guests, Jackson blurts out, wasn't it amazing how that colored attorney, yes, it's patronizing, how that colored attorney creamed John W. Davis? Present is Harlan Phillips, who does Jackson's oral history for Columbia University, and Leonard Levy, who becomes a great constitutional historian in his own right, and they each wrote about it. Jackson, through this process, is writing. Not because he's been assigned to write, because he thinks by writing. He drafts a memorandum to himself. First version, December of 1953, is actually something of a dissent if the court were to be making a decision that the original meaning of the 14th Amendment was to disapprove segregation in public schools. And then through 5 subsequent drafts, Jackson is working and reworking this memo, which is clarifying his thinking for himself, while they are, of course, waiting for Warren to be confirmed and not yet voting and doing hallway talking and percolating. This is a glimpse of Robert Jackson at work. His papers are in the Library of Congress, and this is cutting and pasting before Microsoft made it a keystroke. This is dictating or longhand writing, and then giving it to your secretary who types up, including on carbon paper, a version, and then cutting parts you like and writing new parts and taping it together, and this is one random page, but then giving it to your secretary to do again and do again and do again and do again. And that's what Jackson is doing with this memo. And this memo is a concurring opinion in holding unconstitutional racial segregation. It is preferring that Congress do this. It's saying Congress has power under 14th Amendment Section 5 to legislate. If the Equal Protection Clause includes this protection, Congress has the power to protect what the 14th Amendment contains. We shouldn't be taking the lead here. The South is entitled to blame the Supreme Court because we did Plessy. It's got a bunch of sort of reluctant and couched statements in it. At one point, he shares a draft with his law clerk who says, if your bottom line is that you're with the majority in striking down segregation, why do you spend 21 pages apologizing? Good comment. Good law clerk. Kind of almost Charles Fairman-esque, although Barrett Prettyman was one of these young boys at the time. Jackson finishes writing, and I think what's in his mind the whole time is that advocacy that impressed him so much when he bounded into Frankfurter's chambers. The drafting, let me say 2 more things, in Jackson's memo is not pro-Plessy. despite his law clerk, William Rehnquist, the previous year trying to egg him on in a pro-Plessy direction. It is, if you look at it, for the future drafting. Henceforth drafting. Constitutional rule announcing drafting. In 1954, Jackson follows Warren's lead. They have mutual high regard. They knew each other before Warren was the chief. Jackson spent summers at the Bohemian Grove encampment north of San Francisco, which is all white and rich and privileged and et cetera, and a schmooze fest at which people meet people. And so Governor Warren and Justice Jackson were friends from the Grove. In 1954, when Warren is finally confirmed, the justice he asks to administer the oath is not Hugo Black, the senior associate justice, or the others with greater seniority. It's Bob Jackson. And then at the end of March, Jackson has a heart attack, a very severe heart attack. It's kind of covered up. If you look at the press at the time, it's a mild thrombosis, and he's resting in the hospital. No, he's down on the floor at home. He barely lives. Cardiology in the 1950s involved seeing if he would die, and if the person didn't die, eventually taking him to the hospital and watching him in a bed for about 7 weeks, and he could live or die, and then sending him home. There weren't bypasses, there weren't angiograms, there was nitroglycerin, but not much medication. No understanding of diet, no understanding of vigorous exercise. And so Robert Jackson, who didn't die of thyroid cancer, is now very much looking at the Grim Reaper as the Brown case is heading into its final turn. He spends 7 weeks in the hospital, and Earl Warren visits him a number of times, and after the first few days when Jackson's able to talk and have visitors, they discuss Brown. Jackson shows Warren the writing he'd been doing for himself. He showed it to no other person except his secretary who was typing it and his law clerk who he allowed to read one of the drafts, and now he shows it to Earl Warren. It's not as good as Warren's opinion, but it is conceptually the henceforth decree that is the Majesty of Brown versus Board of Education. In early May, when Warren has gathered the votes and done the drafting and circulated it, he brings the draft to Jackson in the hospital. Jackson's law clerk is visiting. Jackson sends him out. Jackson reads it. Then he gives the law clerk a chance to read it. Then they talk about it. Jackson says, well, it could use a little more law, but I like it. It's honest about what it's doing. It's not pretending that the 14th Amendment is a magic answer, that the original meaning of the 14th Amendment is a magic answer, that Plessy was wrong the day it was decided, that the South is to blame, that the prior court is to blame. It's forward-looking. And when Warren returns to the hospital, Jackson says, I join. I'm in. And I'd like a couple of additions. This language, Warren says no. That language, Warren says no. A sentence. And Warren says, okay, you can have this one. Again, I don't quite love the wording, but the concept is important and goes to this slide. Today, in contrast, my addition, to 1868, when some states made it illegal to educate blacks, many Negroes have achieved outstanding success in the arts and sciences, as well as in business and the professional world. In other words, look at America. Blacks are us. We are together. Our potential is what we're now talking about. And this advocate, as Hasty a decade earlier, that advocate, and the other advocates embody this reality. That's really what this case is about. On May 17, Jackson comes from Doctors Hospital, 18th and H Street, torn down in later years, to the Supreme Court to be on the bench when Brown comes down. He is not leaving the hospital early. That's misreported by some people. But he's also not following medical advice, which is to go home. Leave the hospital, but continue your rest at home. He's missed a bunch of springtime oral arguments. He doesn't participate in a lot of those cases. Jackson says, I want to be on the bench to visibly contribute to the demonstration of the court's unanimity. He's accompanied by his doctor, his nurse, his son, his law clerk. They're all kind of holding their breath because his ticker's not good. But he's doing his job. And he's part of Brown coming down the way it did which in the end is a lot of how he particularly worked out that it should come down. Now, he didn't take it easy in the summer of '54, the doctor's advice. He kept traveling and speaking and working and so forth. This is one tidbit from that summer. He gets invited to the dedication of a plaque that a civil rights organization is putting up celebrating Brown versus Board of Education. And he writes back, "Your invitation troubles me. I think the court has only done its duty and nothing beyond the line of duty, and that it hardly becomes the justices to participate in a memorial to their own work." In other words, don't congratulate a judge on judging. Admire a judge who does judging, because that was his best effort with the matter before him. I don't deserve a plaque. We don't need a parade. We just did our job. And then in the fall of 1954, just a few months later, Jackson has another and fatal heart attack, and he's dead at age 62. So he's not part of Brown 2, except Brown 1, if you read it closely, really foreordains all deliberate speed, remand, local administration of the remedy. That is Brown 2. And that's really perhaps unfortunate in utopian thinking, but it's part of the deal that's baked into the court achieving its unanimity in Brown 1. So let me turn to my final part, understanding Jackson in Brown and on Brown. Here I'll be brief. I hope that I have, in all the foregoing, shed light already on Jackson and Brown, but I'll give you 10 observations. He was not a racist. Second, he was not a closet dissenter, ever, from Brown as it came to be decided. Third, he also was not the architect of Brown. Houston, Marshall, Warren, the entirety of the court. Fourth, he was, Jackson, a thinker, and he endeavored, within all the realities of human psychology and self-deception that's part of all of us, to be honest with himself and in his judging, including in his speaking and in his writing to himself. Fifth, he generally was a restrained judge. He believed within the parameters of lawful government power that policymaking and value picking is for politics, for people, for elected representatives in democratic self-government, not for courts to impose from above. But sixth, his job also had the other half, which was to interpret and enforce the Constitution's limits on government, which is to say, protections for people. And it was there all along. Read his opinion in the flag salute case, West Virginia State Board of Education versus Barnett. The purpose of the Constitution is to withdraw certain questions from the vicissitudes of political decision-making. Equal protection in 1954 is now one of those. Next point, the Equal Protection Clause, in Jackson's view, is a real and serious such limit. And that, too, was there all along. Read his famous opinion in the Railway Express case, which prefers equal protection decision-making because it's a dialogue between the judiciary and the public and the elected representatives. Equal protection says you have to equalize, which can mean level up or level down, as opposed to due process, which means we take this away from you and we declare the substance for the country. 8, Jackson learned what he could from history, but it is indeed inconclusive. He found usefulness in originalist claims because the usefulness was in the counterclaims about the framers or about the public. They're thinking about different points in the past. And this, too, was there all along. He wrote this before Brown in 1952 in the steel seizure case. Number 9, he learned from life, including black lawyers like Hastie and especially Marshall and the Legal Defense Fund team. And finally, 10th, Jackson was happy to join the honest decision that Brown was. It's not much law. It left Plessy versus Ferguson on the books in the past. It was for the future. It was Constitution Day, henceforth. And so in conclusion, I want to serendipitously refer to something that's in your folder and in your packets. Quiet time later tonight or when you can, read Benjamin Franklin's final speech to the Constitutional Convention. This is for September 15th, 1787, which is when they actually voted. And then it took 2 days for the scrivener with the calligraphy to write the Constitution, and it came back and they signed it on the 17th. Franklin was 81 years old and frail, so he couldn't even stand and speak this to his colleagues. James Wilson, his fellow delegate, his fellow Pennsylvanian, read it for him. And what Franklin says in this speech is so beautiful and powerful. To paraphrase just one aspect of it, he says, everybody always thinks they're infallible. Every debate, every contending viewpoint is somebody who's got firm conviction of their infallibility. He anticipates a quip that Robert Jackson wrote famously in his opinion in Brown versus Allen, which is that Supreme Court justices aren't final because they're infallible. They're infallible because they're final. What Franklin was doing centuries earlier is saying, you all aren't entirely happy with this Constitution. Some of you are preparing to vote no. You think you're infallible. I think I'm infallible. But I think we've done something here together that is going to work and is going to stand the test of time. And so I appeal for your unanimity. Vote for this Constitution. Now, 3 didn't, but overwhelmingly the rest did. And what Franklin there is anticipating is Earl Warren working Stanley Reed and achieving unanimity in Brown. Constitution Day is that adjective. It is constitutive. It is self-definition. Constitution is us. It was Philadelphia. It was 1868. It was Brown versus Board of Education. It was Robert H. Jackson. And in our era, it's each of us doing our job, working hard as successors, thinking honestly, not asking for congratulations, believing we're infallible, but then maybe parking that a little bit to join the progress of the country moving forward. That constitutes us. Thank you very much.
Thank you very much, Professor. I'm going to just make an announcement here. We really appreciate that, and it was truly magnificent and extremely educational. And now everyone can adjourn, if they're able to, a reception in the adjoining room. Thank you very much.